Good morning. It's the 22nd of September 2020, and this is the latest episode of the Observation Post with your host, Captain Retired Matt Edwards. Now, I feel a bit foolish doing that, to be quite honest, because I'm not an entertainer. I'm merely trying to basically get the word out and explain things to people so that they won't have the government pull the wool over their eyes. Now, I posted my outline earlier. I'm going to try to stick to the plan as much as possible. I might change the order around a bit. What I said I'd do for my first subject is related to the rest. Well, the fact that an injured soldier is paid a set rate, frozen in time, it's a really onerous problem, a very nasty problem. It's nasty for more than one reason. Okay, let me explain. Soldiers are usually young. So say you have a young private or a corporal who goes to war, they're early in their career. And because they're early in their career, if they become disabled, and then they get frozen at 75% of their salary upon disability under the Service Income Support Insurance Plan, that is a major problem, because they lose the value of their future seniority and promotions. Now, I'm going to throw a bit of a bouquet out to Veterans Affairs because they recognized that the loss of someone's promotion and seniority was a very important point. So they brought in the permanent impairment allowance. Now I'm going to take away the bouquet and I'm going to give them the thorns from the rose bush. Because they brought that in, but then they didn't award it to anybody. Okay? So they admitted there was a problem with the lost seniority and promotions for a person who's injured early in their career, and they brought in a fix for it. But they didn't award the fix to anybody. According to the Office of the Veterans Ombudsman, by year 2010, 4 years after the Canadian Forces Members and Veterans Reestablishment Act came into force, only 16 people have been awarded the loss of promotion and seniority payment. Now, I'm in danger of going far off topic, but I will pursue this train of thought for a moment. People started to realize about the loss of promotion and seniority, and then they started bringing it up, and then VAC had to start paying it. So then the government's response was to get rid of the supplement in 2019. So the supplement for the permanent impairment allowance came into effect in Bill C-55 in 2011. So then Conservative Minister of Veterans Affairs, Jean-Pierre Blackburn, announced that the government of Canada would introduce a supplement of $1,000 per month for the seriously disabled veteran. Now, the problem is that there's a disconnect, I believe, between what the politicians say and what the bureaucrats do. On that note, I'll explain. Okay, Canada has three branches of democracy. Our elected members of Parliament, because we have a British system based on the Westminster system of democracy. And then you have the ministries. They are the executive. They run the government. Okay? The elected people make laws. The government executive, like CRA, Department of National Defense, Veterans Affairs, they're the worker bees. They perform the duties. Okay? And then the third branch is the judiciary. Now, the judiciary is supposed to keep an eye on the other two. But I think the government is failing lately because we seem to have judges that don't understand what their role is. Again, one judge said that a woman should keep her legs crossed to avoid being raped. I'm sure that that's not exactly good advice in a crisis moment. You know. Anyway, that's only one example. So there seems to be a disconnect between what judges should be doing, administering justice, and what they are doing is coming up with cockamamie stupid ideas like that. Okay? Now, in the meantime, getting back to my subject, the point about, and I'll keep the first topic, the 75% or whatever frozen thing, fairly short. But it is a very absurd notion, and I can call it absurd because that's a term used in law when something is so irrational that it shouldn't happen. Okay, in the Andrus versus Grandin Toy Supreme Court of Canada case in 1978, they looked at a young fellow who had been injured in a car accident, and they gave him 150% of his present income as his future earnings capacity loss. Now, they didn't freeze him at 75 or 90% and say, we're going to save money at your expense because your career would have gotten better. Everybody, as they advance in their career, they get promotions and seniority. That's a given fact in our system. Unless you're the kind of person which goes to work, punches your time, and don't bother to become more competent and to learn things as you go along. Do you follow me? Everybody gets paid more the further you advance, the nearer you get to retirement. So on that note, before I forget, that's another whammy, because if the person gets injured in military service, they're off doing war, battle for Canada, they get their orders to go into war, they become disabled, because the enemy's not going to sit there and just sit back and say, come and shoot me, come and kill me. So they're going to try their best to kill you first. Now, if you become disabled, you shouldn't have to face a penalty according to, the laws of the economy, that your career will advance as time goes on. I mean, the police, they kind of handle this differently because they leave the person in their job and then continue to pay them. Many police offices, police forces. But that doesn't necessarily solve the promotion problem. It would solve the fact that they'd still be getting more than, say, 75 or 90% because they get 100% of their pay. But I don't think anybody looked at the issue of should they get a promotion after they become disabled and continue to receive their salary. Now, don't know the answer to that. That's one thing about me. I say a lot of things here, and I claim a lot of things. But I claim things that are factual. I don't claim things that are just my opinion. Okay? If I say that pensions are property, I'll back it up with a case, like the Clark versus Clark's case in Supreme Court of Canada in 1990. And the important thing about that case is that it was in pay. We're not talking about a pension that was waiting for a buddy to get his pension. We were talking about a pension that was in pay, and he was getting divorced, and then it was determined to be property, even though it was paying him each month. So I would have to refresh my memory to see exactly why the arguments were that it was income at one level, and it was ruled to be income, and then ruled to be property instead at the other end. Because it made a difference legally, you see? It made a difference in that case, or it would not have gone to the Supreme Court of Canada. Now, I'm going to get a shot in at the Supreme Court of Canada now. Why didn't it hear the Equitas case? I didn't necessarily agree with the approach used by the veterans trying to sue the government on the Equitas case, but I had their back in that I wanted them to win, right? So, why did the Supreme Court not hear the case? If the Supreme Court heard the case, then we could have a reading of the case materials, and we could see why, they came to that decision. But by flat out refusing to hear the case, that sounds like a dictatorship, Like, in a way, no one should tell them what they have to do because they're supposed to be independent. But on the other hand, they're judges and they're responsible to democracy. They're accountable to democracy. So why didn't they have a free and open case, like where people could attend and people could hear the arguments? I mean, that's one of the approaches used for law, because you have free and open court cases. You don't have behind closed doors court cases, because justice must be seen to be done, not only to be done. Now, that's not my main topic today, so let me segue into the second thing I put on my outline. Pensions are property. Well, I just covered that. So I'm going to go on into the third one. Now, for those that don't know me personally, I used to be a teacher, okay? So I was growing up in a small town called Lawn, Newfoundland. Population there between 700 and 800 to 1,000 people. And I had hoped to become a teacher and then get a job back in my hometown. Now I was thinking if I got to be a teacher, I should try something that I love. So I became a physical education teacher. So I obtained a conjoint degree in Bachelor of Physical Education and Education. Now that's 50 courses, 40 regular courses and 10 education courses. Now I also did a minor in English literature, and I almost had a major. I had 10 courses. I needed 12 to be a major. That's because I love reading. Now, the thing about me is that I was thinking about some ways to try to educate the public. So I thought of last night or a week ago or whenever, there's one technique if you're doing a test. Sometimes you say compare and contrast something. So I decided to sit down and write it up. It's in my outline. You can hear me talk about it. I'm going to look at my outline that I have on the computer, and if I think of anything else, I'll add it. But I decided to compare and contrast the income replacement benefit at Veterans Affairs to the earnings loss benefit, income replacement benefit at the Service Income Support Insurance Plan, because they're both roughly similar. However, there are differences. Okay, so let's pretend that this is a test and I'm doing a question. Compare and contrast the Service Income Support Insurance Plan to the Veterans Affairs Income Replacement Benefit. Well, I said, first of all, the Service Income Support Insurance Plan is a Department of National Defense program, and the Income Replacement Benefit is a Veterans Affairs program. Now, to some people, that's a very important point, because they're not the same program. They're different programs under different departments. So as much as they want to integrate them, they want to harmonize them, can they legally? Now, I'll follow up on that later. Number 2 point, I said, as if I was doing bullet points on a test. The Service Income Support Insurance Plan has visible premiums, while the Earnings Loss Benefit, Income Replacement Benefit has invisible premiums. The premium for the Income Replacement Benefit, and don't ever doubt that there are premiums, the premiums are service. Now, they don't monetize it, they don't advertise it, but you don't get something that you didn't pay for. So you earned the right to the income replacement benefit under the table, in between the lines, read in between the lines. Basically, it's like the Perry versus Cleaver 1970 case, 1969-1970 case. And the judge said, you know, the working man here, his service has value, and because his service has value, even though he didn't pay for the pension, he got a pension, and you can infer that his service had value. That would have been the same as his contribution. So he was getting a pension that he didn't have to put any money up for. And someone wanted to reduce the amount of damages by taking into account the pension because he didn't pay for it. That was their technicality, their legal technicality. They were trying to get one over on him. They wanted to save money at that person's expense after having made him a disabled person, which I think is despicable. Now, the third bullet point I have in my outline is that the Service Income Support Insurance Plan pays 75% currently. Now, it used to be 75%. It originally started at 60%, and then they had supplements for children and spouses. Now, if that sounds familiar, that's the way the Pension Act does it. Okay? The government has a habit of continuing programs doing the same thing all the time. So when they set up SISP, they set it up like the pension. They had a basic pension, I'll call it, 60% of your wages, and they had a supplement for your children and your spouse. Exactly the same. Now, sometime in the past, they changed it, and they made it 75% across the board. Now, that wasn't for the reservist. The reservist, like myself, wasn't added to the policy until 1991. And in 1991, they added us to it, but they made it voluntary, just like it did at the very beginning for the regular force person. Nobody bought it, so the government made it mandatory in 1999, just like they did for the regular force person in 1982. So I'm comparing and contrasting that, how they treated reservists and regular force. Yeah. Anyway, right now, the income replacement benefit is 90%. But as you can tell from my skepticism here, when I turn up my lip like this, they changed it from 75. They changed it to 90. Who's to say they can't go back down if they run into money troubles, right? So, everything that they do, you would like to be able to count on it. But because of the vagaries of the government thinking, because of budget constraints and stuff, 5, 10 years down the road, 6 months down the road, they might say, we can't afford to pay this. And they might change the rate. Especially when the shit hits the fan about the stuff that I'm working on. Because the stuff that I'm working on is going to increase their expenses. Because the people are going to have to get more money. Obviously, the government's not going to like that. Now, so, back in October 2016, the government decided to increase the earnings loss benefit 90%. Now, it is my hypothesis, this is not a fact, but it is my hypothesis based on what happened when I look at the facts. It is a fact that the Department of National Defense Insurance Plan did not increase to 90% exactly like the earnings loss benefit. So they wanted to save money and they didn't want to pay an extra 15%, right? Now, if they had, it is my opinion this time that we might not know about the double dip clawback. Because people getting 90% under both programs together, or one program or the other, well, we probably never would have discovered it because there wouldn't have been 2 payments. But when both departments had to pay, VAC avoids most of the payment, and they top up the Service Income Support Insurance Plan. So, VAC is getting a benefit by not paying. Now, because both were paying, and because both invaded the veteran's privacy and asked questions like, do you get the Canada Pension Plan? Do you get the Canadian Forces Pension? Then VAC caused a problem for the veteran because they take into account something that the Department of National Defense already took into account, which everybody knows, common sense. And the common law says you can't do. Bapu, Ontario Court of Appeal, 1998. State Farm, in that case, wanted to use one provision of the Ontario Insurance Act and another provision under the Ontario Insurance Act to achieve a deduction. The court said, if you deduct the value under this section of the Act and that section of the Act, you'll be recovering, clawing back money twice. Just like the person who's getting damages can't get compensated twice, neither can the person paying damages save money twice. You see? So they're not allowed to save money twice by using the same accounting item twice. They're just not allowed to, period. Anyway, it is my opinion that the 90% thing, if VAC and CISIP had both moved in conjunction to 90%, the people on CISIP would have stayed on CISIP, the people on VAC would have stayed on VAC, and there wouldn't have been a problem. Well, I'm starting to change my opinion even as I speak. Because upon medical release, according to the program arrangement, section 3.2.1, it says that CISIP will be the first payer on medical release, and CISIP is 75%, so they wouldn't have avoided it. Forget everything I just said. Well, upon further reflection, this still would have been a problem. But, common sense, due diligence, they should have thought of this problem. I don't get paid for it, but I thought of it. They get paid to think about stuff like this. Why didn't they think about it? If they have a program arrangement, obviously they're thinking about these two programs working together. Somebody should have had a light bulb go off over their head and said, hey, what happens if we deduct the Canada Pension Plan disability and Veterans Affairs, if it was the person at D&D saying it, and the people at Veterans Affairs, they take it into account, and they have a program arrangement, so they should have picked up the phone, called each other, and discussed it. Now, that could have been the worst thing that happened because they would have found a way, I think, to cover it up. But because they didn't, we have a chance. And I'm pushing this all the time because I want people in this boat to get pissed off enough to call the Veterans Ombudsman, call their member of Parliament, call a senator, call the media. I want people to realize that if they have money deducted at the Department of National Defense for their Canadian Forces Pension and their Canada Pension Plan disability off of their Canadian Forces Pension and their CISIP, and then Veterans Affairs gives them a top-up to 90%, and they claw back the value of their Canada Pension Plan and Canadian Forces Pension, then I want people to get fucking pissed off with this shit because it's not right. Because if one does it, the other one can't do it. So you could have D&D do it all, you could have VAC do it all, but you can't have both of them doing it at 100%. You could have one of them doing 50% and the other one doing that 50%, and that would be like the Canadian life and health insurance industry. But you know something? That is illegal. Why is it illegal? It's against privity of contract, okay? Privity of contract says that the people that are party to a contract, that's their business, and it's nobody else's business outside the contract. The Service Income Support Insurance Plan is allegedly a contract. It's a contract between the soldier and Canada, and it's none of Veterans Affairs business. It's between the Department of National Defence part of Canada and not the Veterans Affairs Canada part of Canada. Now, I just thought of that, but it kind of goes against, and see, I have obsessive compulsive personality disorder, so I shouldn't tell you something that might take away from your confidence in what I say. But what I just said goes against my there's only one Her Majesty the Queen idea, that each department can't try to say that this is my department, not their department, so I'll do what I want to do. Because basically, all of the government is supposed to be the Queen, the representative. So, if we sue Canada, it's not like Dennis Manouche versus Department of National Defence. It was Dennis Manouche versus Her Majesty the Queen. Now, so I shouldn't be telling you that, but that's my obsessive compulsive personality disorder. I want everybody to have all the facts, not just some. Now, anyway, moving on. Manulife administers the CISA policy, and Veterans Affairs administers the income replacement benefit insurance. Because that's what people don't seem to understand, okay? Now, again, I'm kind of ad-libbing, but that's the way I would have made up a lesson plan when I used to teach. I'd make some notes, and then I'd talk about things because the note would jog my memory. Well, if you look at the Pension Act is a form of insurance, an indemnity insurance, to pay you for the lost earnings capacity of your injury in service. Now, I don't know exactly what is the stuff under the new Veterans Charter, the Canadian Forces Members and Veterans Reestablishment Act, the Veterans Wellbeing Act. They changed the name of the act even. So, what is it? Is it an indemnity insurance or is it a non-indemnity insurance? There's only two forms of insurance, okay? So it's either indemnity or it's non-indemnity. Now, if it's an indemnity insurance, it can claw back other forms of indemnity. If it's a non-indemnity insurance, then it has no right to claw back things. And it has no right to be clawed back because of its legal nature of being a non-indemnity insurance. See? And while some people might say, I can argue both sides of the coin. If I was the Department of Justice lawyer and I was trying to argue in a court that the earnings loss benefit, income replacement benefits are an indemnity, I would say, well, these benefits were a suite of benefits that were replacing the suite of benefits under the Pension Act. And the Pension Act was an indemnity insurance. So therefore, it goes to logic and reason that the benefits under the Veterans Wellbeing Act are also an indemnity insurance. Now, if I was arguing the other side of the coin, I would say, the Service Income Support Insurance Plan is a non-indemnity and contributory insurance as per the Soltz, British Columbia Court of Appeal case in 2006. So the earnings loss benefit was based on a design from the Service Income Support Insurance Plan. So therefore, the income replacement benefit part of the new Veterans Charter is non-indemnity and contributory. You see? So I don't know which one is the right answer, but I do know that they can't touch things like the Canada Pension Plan or the Canadian Forces Superannuation Act because, first of all, the government put laws in place to protect our savings for retirement. So the government doesn't want poor people after they stop working. So they make people to save money, which is what pensions are. So if you get a payment to replace, I hate to use that word, your income, it's insurance, not income replacement. If you get money after you stop working, if you're a civilian, you work. If you serve in the military, you stop serving. Now, if you have your Canadian Forces Superannuation Act pension, that's property being returned to you because they took the money off your check when you served, when you were healthy. Now, Canada Pension Plan, it's the exact same thing. So you're getting your property returned to you. Now, if they want to take it into account, they don't have the right. If they had the right, it would be under the Constitution, Section 92(13). But 92 is about the provinces. Section 91 is about the federal government. So when they set up the Constitution, they divided the powers. Canada's a federal government, but we have a it's a federation of provinces. So when they were looking at how to divide up the power, how to divide up the responsibility, they decided that certain things would go to the federal government, big things like national defense and railways, expensive things, and that little things like healthcare would go to the province. Now, that didn't anticipate Medicare back in the 50s. See, when they set up the Constitution, they didn't see that healthcare was going to be one of the biggest expenses that the government has. But at the beginning, they decided to put all the expensive stuff with the federal government and all the cheap stuff with the provinces. Now, one of the things about property and civil rights is that the right to sue someone when you get hurt is a provincial responsibility. So you go to court if someone hurts you, and you sue the person in tort. Tango, Oscar, Romeo, Tango. I'm not a lawyer, but I've read a lot about law. So the intent of tort damages is the person that hurt you has to repay you for the injury that they caused you. Now, civilians who got injured on the job had a problem because they had to prove that they got hurt in service on duty. They had to prove that the employer owed them a duty, and if another employee caused it, then the employee might get sued instead of the employer. So back in the early 1900s, they came up with a thing called the merited principles. Now, the merited principles in the common law in provincial workers' compensation is, I'll recall some of them off the top of my head. First is that the employer must pay all the premiums. Secondly, the employer got the right to sue from the employee in exchange for the workers' compensation. So it was a quid pro quo called the Great Compromise. But moving forward, a more modern view, like from a guy named Peter Weiler, who was reviewing the Ontario workers' compensation in the 1980s, and I read his reports, he said the more modern view is that the injured worker is supported by the other workers, that the cost of the workers' compensation system is either passed up to the consumer if the company makes something that they sell to the public, or if they don't sell something to the public, it's passed down to the employees in the form of reduced wages. Right? The employer is not going to simply ignore the fact that it has an expense when it's doing its accounting, when it's doing its books up, its paperwork. It's going to take into account all of its expenses. So one of those expenses is the workers' compensation premiums. One of these expenses these days is the Canada Pension Plan and employment insurance. All those things. Now, so those have to be taken into account when they do up a business plan. Now, so these days when they look at those principles, they're looking at the form instead of the substance. The form is that the employer pays all of the premium. The substance is the ultimate cost is passed on to the public, the worker, because the worker is a consumer. Okay? So when he's not on the job, the worker goes to shop. So the worker goes to shop and he buys products. He might buy products made by his own company. So in that way, the higher cost on the product means that he is subsidizing his own disability if he becomes disabled. Now, this came up in a New Brunswick case called J.D. Irving, is the way I call it. It has a big longer name in real legal terminology and references, citations. But I try to think of one name, and I think of the level of the court, and I think of the year. Those are the three things that I put into my citations. It's my own little nomenclature, even though I know it won't get popular. But it's how I recall cases. So, the J.D. Irving, New Brunswick Court of Appeal case in 2012, the New Brunswick government said that Canada Pension Plan would be used to reduce the workers' compensation paid to a disabled worker in New Brunswick. And then it was ruled that that was illegal. Now, why the hell did they try to do that after the Sarvanis Supreme Court of Canada case in 2002? Why did it take 10 years after the Sarvanis case for the J.D. Irving case to come up? I don't know. But the thing is, if you look at the Sarvanis case, the federal government wanted to reduce its tort damages under the Crown Liabilities and Proceedings Act when a prisoner fell off the roof in a jail. Then he sued the government for negligence, I suppose, and he won. So the Department of Justice lawyers had this bright idea, which was fucking stupid, in my opinion, to go after the Crown Liabilities and Proceedings Act, Section 9, to call the Canada Pension Plan a pension that bars a lawsuit. Now, I'm glad they did it because now I can use that case against the government. But in my world, they shouldn't have tried to argue the Canada Pension Plan should be used to reduce the damages for the federal government to save money for the taxpayer. Because that's not the way it works. The Canada Pension Plan was supposed to supplement people's money, and Judy LaMarche said in 1960-something that it was going to provide help as of right instead of need. So basically, it's your own money coming back to you because you bought insurance, a social insurance. The Canada Pension Plan is a social insurance, right? Now, I'll mention something as I said that because I was looking at the Green Paper from 1983 this morning. Every now and then I get a bit insecure about all these things that I tell people are facts. So this morning I tried to reaffirm my belief, my understanding that pensions are property, and I thought, why not look at the 1983 pension, Green Paper on pensions? Now, sure enough, it was stated right there, pensions are the jurisdiction of the provincial government. Right there in the federal paper on pension reform. Now, you see, that's a very important point. Pensions, being property and civil rights, fall under the provinces. But federal employees need a pension. So, what does the federal government do? They pass an act, or two or three. Canadian Forces Superannuation Act, the Royal Canadian Mounted Police Superannuation Act, and the Public Service Superannuation Act. Now, as long as those acts stay within the same rules as the provincial government, we don't have a problem. But if those acts go outside of provincial law and they go out on their own, then you have a problem because the federal government doesn't have jurisdiction over pensions. Right? That's just the way it is. Now, the other point I saw, and this is kind of off topic, but not quite. They said under the disability part, because I got curious and I punched in, I don't read all these documents verbatim, book to, beginning to end. I usually do a word search. Now, if I get curious, I'll read it over and over, and I read sections and sections. That's why you might see a lot of documents that I post for people to look at. But I haven't read them cover to cover. I'd have to have more time than I have on my hands to do all that. So I was searching the word disability, and up pops this commentary on the Canada Pension Plan disability. And the people who wrote the Green Paper, and it was only 17 years? 17 years after the Canada Pension Plan came into effect. Canada Pension Plan came into effect in 1966. The Green Paper was written in 1983, and they were putting crap in there like they don't understand why there's a disability insurance in the Canada Pension Plan when that's about pensions and not insurance. Well, the Canada Pension Plan is a social insurance act. You get a social insurance number to access your social insurance that the government brought in 1966. Now, the comprehensive insurance contains 6 different benefits. A retirement pension, a disability pension or insurance. It has a death benefit, it has a children's, and it has an orphan's, and it has a spousal pension. Now, those are the 6 things that they decided to put in there that your contributions, your premium, bought. Now, only 7 years after the Canada Pension Plan came in, you had a case that I call Gill Supreme Court of Canada, 1973, which says what I say, that this is a social insurance program, and that basically the Canada Pension Plan, the contributions are like premiums, you see? Now, the thing about that is then I read other crap, like a case in the tax, and someone was arguing the Canada Pension Plan was an insurance, and the judge said, I don't know of any cases where they say that the Canada Pension Plan is insurance. Well, first of all, Judge, I suggest you read the Hansard and not case law, because the Canada Pension Plan is a man-made, a legislative-made plan. It's not something that a judge ruled on, like in the common law. Like a common law case is important. Canada's common law democracy. I might talk about that one of these days. But, when we're talking about the intent of a parliamentary law, I suggest you go back to the record of parliamentary debate. So you look at what the politicians said before the law came into effect. Now, that's not law. If a judge is asked to rule on an act, to interpret something, they can't use the Hansard as the definitive source. It is a secondary source showing how the law developed. But what the law ended up in writing as it stands, that's what they usually have to do when they're asked to interpret the law. Now, on that note, I'll slip a little bit of news in here. I was looking through something the other day in the Veterans Wellbeing Act, and I saw that they changed Section 9. Now, Section 9 is very important to someone like me, because I have obsessive-compulsive personality disorder, and I know that the government decided they were going to have two gateways to get into the new Veterans Charter. One was the medical release gateway, so that was Section 9. And then, I think it's either 8 or 10, there's the needs gateway. So you have two ways to get covered under the Veterans Affairs Insurance. You get out medically, it's more or less automatic. You get out other than medical, and you have to go to them, and you have to apply within 120 days, or with certain wiggle rooms here and there. And then you have to show that you're totally disabled, and it's as a result of military service. Now, the change that they made, I was shocked by, because every time I talk about all this stuff, I say that Veterans Affairs has a mandate to help disabled veterans. That's all they do. But in Section 9, in the latest version, they say that a medical release person can get released, and it doesn't have to be caused by service, and they can still get into VAC. I was shocked to see that, okay? Normally, Veterans Affairs jealously guards its right to determine service attribution, okay? So now here they are, lowering the bar, and basically getting into service income support insurance plans jurisdiction, because that's the insurance covers both on and off duty injuries, you see. So here's Veterans Affairs, and like the way I explained it, I didn't call them, they called me the other day. The Office of the Veterans Ombudsman gave me a call, and I was bringing them up to speed. I told them about that section of the act that got changed, and I wasn't impressed. But I also told them that my base allegation here that's causing veterans so much trouble is that the Department of National Defense and the Department of Veterans Affairs don't play nice together. So because they don't play nice together, they play a game, a power and money game, and employees and whatever, and they play a game with us as the pawns on the board. So, for example, the Canadian Forces Ombudsman said that the Canadian Forces should determine the service attribution in a report a few years ago. Now, I saw what brought that into my head was I saw today when I was doing a little bit of research. I don't want to do research, but every now and then I have something comes into my head and I reluctantly start looking up stuff. I found a report in the past where they said that the Canadian Forces ought to help out and do the stuff about if an injured soldier can get a job in the federal government, instead of the Public Service Commission doing it, that the Canadian Forces want to do it. Now, you see, it's natural that people want to make their jobs secure, right? They want to have a secure job. What used to happen at Canada Revenue Agency when I worked there is the CRA was always looking for more work that it could get from the provinces or the cities or somebody else. Like if they were collecting debts, like my job was a tax collector, was collecting debts. So if they could come to some arrangement with a city or a province, then they could go and collect. We were the experienced tax collectors. We could go and collect it on their behalf. Now, obviously, there would have been quid pro quo and deals and money changing hands. But what it is they were trying to protect their power, influence, and not get cut back, right? Because the government, once upon a time, back in the 50s and 60s, they were always talking about the Department of Veterans Affairs ceasing to exist at some point in time. Now, that was a pretty short-sighted view because they were viewing that there was not going to be any more war. You have World War I, you have World War II, and they figured that that was it. The people that were in the system were going to be in the system and we're not going to have any more veterans. Short-sighted thinking, in my opinion. Now, but Veterans Affairs, they saw this was coming, and they changed the veteran definition back in the late 90s or the early 2000s. You had to be a disabled veteran in order to be a veteran at first. But then they said you just had to be in service. You just had to have X number of years, X number of courses, and we would consider you a veteran. Now, you would have to be stupid not to see that they were worried about their client population declining so that they would be irrelevant. So they changed the definition of veteran so that they would have a job. Now, that's my allegation. I stand by it. Then they didn't see the Afghanistan war coming along. So we had the two twin towers, get blown up by them terrorists in planes. And then because the Al-Qaeda people were getting trained in Afghanistan, as far as I know, my understanding is that the United States invoked the NATO, somebody attacked a member of NATO. So Canada was obligated to go into war with the U.S. And I'm going to tell you, my opinion and a lot of soldiers' opinion at that time was good. This is what we were trained for. None of this peacenik bullshit like we don't want to fight war. If we were attacked and that was our duty, why wouldn't we do our duty? So, I don't have a problem with going to Afghanistan, you see, because we had whatever. Now, over time, mandates and goals change. So after the basis and the Al-Qaeda was wiped out and then it becomes a bit more political, it might be a bit different. Now, on that note, seeing I'm talking about Afghanistan, I read various reports, two by the Parliamentary Budget Office, and they predicted that there was going to be a huge cost in the Veterans Affairs programs because of delayed onset PTSD and other things, around now. So basically I'm saying they knew all this shit was coming. They planned ahead. But where were all the people that were supposed to get all the programs ready for the influx of people? That when the shit that people saw when they were over there, I think 30,000 soldiers served in Afghanistan from Canada over time. We were there from 2001 to 2012, I think, 11 years. So there were many people that served there. And sometimes it takes time for things to come about. Invisible disabilities like PTSD. Or maybe they were fed that goddamn drug mefloquine, that untested, unproven drug that caused people to have screwed up their head. Right? So basically the government caused those injuries. And I don't agree with them trying to cover it up and not admit liability. Now, I'm going to get way off topic and run out of my time if I don't watch this. Let me get back to my outline again. Back to the compare and contrast. Okay. The Service Income Support Insurance Plan has a voluntary rehabilitation program, but the Veterans Affairs program has a mandatory program, which I believe violates the Constitution and the Charter, because we are supposed to live in a free and democratic country. So if they say to someone who's been injured in service that, I'm sorry, unless you do this rehabilitation program, we're not going to pay you any money. That violates the compensation principle, that violates the merit principle, that violates the Charter, that violates common sense. These people are acting as if they're paying welfare. I have a huge problem. If you take a healthy person, they're contributing to society with their taxes. They're protecting the nation through their service in the military. You send them to war. They become disabled. When they become disabled, you then say, we're going to give you welfare. And if you have the means to support yourself, like your Canada Pension Plan and your Canadian Forces Pension, then we're not going to pay you compensation. Stick your middle finger up to them sons of bitches. You tell them, listen here, buddy, I served my country. You cannot reduce my compensation for injury simply to save money for the taxpayer. I was protecting the taxpayer when I was in Afghanistan or wherever. Okay? It's the principle that I'm saying that needs to be defended, right? The principle that a person is entitled to full and fair compensation for their injury. Okay? Now, ordinarily, it would be the person who hurt you who has to pay you back. But because you can't send a bill, now, I'm hesitating, but because of my OCPD, I'm going to say it, that Cotter settlement in the States, they sued him, and they had a big judgment against him, so that if he ever got a judgment or something from Canada, they'd intercept the money. Well, see, I'm going to come across as, people are going to hear me say this and think that I'm foolish. Look, if Canada had not interfered with Omar Cotter in Guantanamo Bay, that would be a problem between him and the United States. But because we sent down, as far as I know from reading the reports, we sent agents from CSIS down there to talk to him, and they interviewed a Canadian citizen being held by the Americans who was getting waterboarded and all that shit, and he was a minor at the time, as I understand it. So I have a lot of sympathy for people that aren't fully formed, okay? You can't sign a contract. You can't have sex when you're of a certain age because you're a minor. So many people, and General Romeo Dallaire had a program for helping child soldiers. So if you look at him as not a terrorist, but someone who was indoctrinated by his father, who was a fucking terrorist, then he got caught up in all this shit. Now, if he can reform his ways, and he is getting paid damages in relation to his injury by Canada, I got no problem with that. Now, I'm going to put a caveat in there. The one problem I have is it seems like it's a certain so many $1 million solution that the government always gives these people the same amount, it seems like. Now, I would argue that the amount of the damages might be different. He has to get damages to make him whole. But I think the Department of Justice screwed the pooch in just simply passing him X number of dollars without looking at his situation and analyzing how much should we pay him. maybe he would have got more, but I don't know. But it seems like me that they have a cookie cutter approach, that it seems like if you're in this situation, here's your chunk of money and go away. Okay? Now, that could be a politically charged situation. I'm going to bail out of that. But that's my opinion. Now, I mean, I'm not a judge. I'm not a member of Parliament. I can tell you what my opinion is, and you can take it for what it's worth. 0. I mean, what does it matter? I didn't have any influence on that case. Okay? But everybody has opinions. Opinions are like assholes. So I have an opinion that the government should have tried to negotiate a lower payout. But they had to pay him something. That's my opinion. Anyway, let's get back to my outline here. CSIP makes the veterans apply to Canada Pension Plan Disability. And Veterans Affairs takes advantage of that. Okay? So I would refer to the Sketchley Federal Court of Appeal case in 2005, where the Sun Life policy does it for the Treasury Board people. So it's a big racket, as Arnold calls it. So you scratch my back, I'll scratch yours, seems to be their attitude. Now listen, on that note, anybody who's watching, and if they got the Canada Pension Plan, and they had CSIP, and they had the Canadian Forces Pension, did you get a refund from CSIP because your Canadian Forces Pension went down because of the bridging amount? Now, the reason I asked that is that when I got my Sun Life and the CPP disability and my Public Service Superannuation Act pension, I got a letter from Sun Life and it drove me up the wall, and I called them up and I said, listen here, how are you saying that I owe you money? Now, what happened was I was anticipating them sending me a bill for getting the Canada Pension Plan Disability retroactive amount. So I didn't read it correctly, and the person shit on me and said, listen, you're reading the letter wrong. It's not that we're saying you owe us money. We're saying we owe you money. Now that flabbergasted me, okay? I called them up, wanting to rip them a new asshole. And then, instead of them saying that you owe us money, they said we owe you money. Now, what are you going to do there? Right? It deflated me. My whole argument was thrown out the window. But their argument was, they said, listen, your your Public Service Superannuation Act pension went down because of the bridging. And because we pay 70% of your income before you became disabled, that meant, because the Canadian Forces clawback went down, that we couldn't take as much money into account. So therefore, we owe you money. Common sense, right? Now it occurs to me that CSIP doesn't do that. So, I'm curious, what is the way they do it at CSIP? If you get your bridging amount, because you get the Canada Pension Plan, so your Canadian Forces pension went down. Now, because CSIP is taking into account your full Canadian Forces pension plan, and they're supposed to pay 75% of your income before disability. Now, because your Canadian Forces pension went down because the Canada Pension Plan bridging came into effect, did CSIP send you a check? Because they overclaw back? I think that's a very good question. I don't think they do it. by the way, my case with Sun Life was really weird because I didn't send them an irrevocable consent form. Because I didn't send them an irrevocable consent form, then the money from my Canada pension plan didn't go to Sun Life. And in fact, they had started what they call estimation in March of 2014 on me. So they started estimating my Canada pension plan at $1,200 and something bucks, and I was only approved at $1,018. So they were over collecting right there and then because they used the estimation process. So the fact is, they make everything complicated, right? They have a 2 or 3 way transaction. You get the Canada pension plan, it causes your public service Canadian Forces and RCMP pension to go down. Therefore, your insurance goes up. But then, because you got the Canada pension plan, your insurance goes down again. So it's like they're giving with the left and right hands, and they're making us really, really confused, right? Now, in my situation, they said they were going to give me $10,000 back. But then they changed their mind and said it was going to be lower, right? So here's the problem with a lot of these things. No matter what we say, they are going to do what they want to do to save money. So I can tell them, listen, you're wrong here, but they control the flow of money, right? So we have very little power in this process, which goes against all the stuff the government wants to say about we're going to have people, their input. We value their input. Yeah, right. They value their input so they can just ignore it because, they shouldn't be doing all this stuff. You can't explain to me that it's fair that an irrevocable consent form goes on file and the government helps the insurance companies. And I think it's because of bias. Okay, I put it out there today. I was going through the 2007 Treasury Board report on total compensation. And I saw the numbers of how many people are in the federal government when you count all of them. You count the core of government, you count the separate agencies, you count the RCMP and the Canadian Forces and other stuff. It was like 450,000 people. Now you got about 500,000 people that work for the government. That means the government's going to have one of the biggest long-term disability plans in the country, if not the biggest. So, if they look the other way on the Canada pension plan being deducted, and the Canadian Forces and the RCMP and the public service pensions, they are going to directly benefit from looking the other way on the long-term disability lower payment, you see? So, bias is a major problem. We should have the courts overseeing all this, and the Ombudsman and the Auditor General. They should be looking into all this stuff and keeping an eye on people. Because I was reminded of a documentary I was watching one night. I was flicking through the channels. I wasn't watching the whole thing, but it talked about the fact that people are more honest when someone's watching them. And the documentary had an experiment where they said that there was a ghost in a room. So when they told the volunteer, when they didn't tell the volunteer there was a ghost there, they might cheat at whatever they were doing. But when they were told a ghost was in the room, inexplicably in my head anyway, people were more honest. So whatever it was, I think it was like a test and they had the answers there, like you could look at it, there's no one else there. But when you were told that a ghost was watching, people were more honest. Now you see, this is what's happening, I think. The Canadian government passed laws like the Canadian Forces Superannuation Act, Section 83, the Canada Pension Plan Act, Section 65.1, the Public Service Superannuation Act, Section 10(10). They passed all these laws to say that nobody could touch our pensions, our money for retirement. But then, faced with budget pressures, they look the other way and they don't enforce the law. Now you see, that goes against the rule of law. And I'm reminded of that rule of law thing that Prime Minister Trudeau said about that immigrant, that Huawei executive passing through that they arrested for the United States. But I'm not going to talk about that. I'm just wondering if the Prime Minister and many people think that the rule of law is thinking about the statutory law when the common law also has to be obeyed, right? So under the Bradburn rule, you are not allowed to take into account things like SISIP to reduce damages. Now, Veterans Affairs takes into account SISIP to reduce damages. If you looked at the SISIP payment as a non-indemnity payment and the VAC payment as an indemnity payment, you're allowed to get both because it doesn't offend the compensation principle. So you can get both because one is paid in contract in relation to your premium. and the other one is paid in relation to your injury in service to Canada. Now, if they were following the regular common law rules, they would say we had to obey the rule of law, we had to obey the Bradburn rule, and therefore you can get both your insurance through Veterans Affairs, which is an indemnity insurance, and your non-indemnity insurance through the Department of National Defense because you bought it. But these people are trying to say they're all the same. They're trying to say they're all the same because they want to claw it back. They want to claw it back because they want to save money. Now, saving money is not necessarily a bad thing, but you have to save money legally. You can't save money by doing illegal things. Crime is not supposed to pay, right? So when the government overlooks the fact that it wrote laws to protect our pension properties, and then it overlooks that in order to save money for the taxpayer, well, it's not doing any of us any favors when it overlooks the law, because you're condoning illegal activity. Now, everybody knows you're not supposed to condone illegal activity because then it makes people more dishonest. Society goes to the dogs. You have to have an honest society. There's always going to be outliers. There's always going to be people who don't listen to the rules. But in general, we need people to obey the rules and do things that are good for society. What we don't need is the government acting like everybody else. The government has to lead, not follow, right? I think a lot of people know about leadership who are watching. Hopefully they're watching. And the government is following instead of leading. That is one of the problems. Now let me get back to this so I can call her quits soon. CISIP is taxed under Income Tax Act Section 61F, but income replacement benefit is taxed under Section 61F.1. I mentioned that because they're not the same thing. Why do they put them so closely in the Income Tax Act when they're not the same thing? First of all, the Income Tax Act Section 6 is the fringe benefits section. Would you call the payment to a disabled veteran in Canada's service a fringe benefit? I certainly wouldn't. I would call it a core benefit. If you're going to have someone who's going to serve Canada at the risk of their life and limb, you don't give them a fucking fringe benefit if they become disabled. That's utter bullshit. Okay? Now, again, because I don't want to be talking all day, Income Tax Act Section 61F5 allows the career contributions that are made by a soldier to be deducted before it gets taxed. Section 61F.1 does not have a Section 5. So that is the rare occasion where the CISIP side of the house has a better benefit because you don't have to pay taxes. Say you served 30 years. Say you spent $30,000 in premiums. According to the law, the first $30,000 you get is going to be tax-free. Now that's in simple terms. But the problem is, and I may have covered this a bit in the past, and I may cover it a bit in the future, if you ask, say, Manulife for a copy of your career contributions, Master Corporal or Corporal Louis Dufour from Quebec, he asked $329, he told him, from 1988 to the year 2000. Okay? That doesn't have what I call the air of reality. That's not a credible figure. However, if someone wants to do this, I suggest you go to the Canadian Forces. They were the ones who paid you. We're not talking about the insurance. We're talking about the contributions that were taken out of your pay when you served. So why would you go to the insurance company administering the policy and ask how much did you pay as career premiums? You should ask the people who had the pay records. That to me is common sense. So if you intend, as I say, here's what I say about taxes on CISIP. First of all, it shouldn't be taxed. So you send in an appeal, you tell the government it shouldn't be taxed, period. However, while you're waiting on them to give you the full refund, you tell them about your career contributions. You served 30 years, you had $30,000 or $40,000 in premiums. Therefore, for the first $30,000 or $40,000, they can get stuffed. Okay? So basically, you're supposed to get tax-free insurance for the first little bit. Now, that's supposed to be to prove a point. Because when they start examining it, maybe then they'd see that it's not supposed to be taxed at all. 75% of Canadian long-term disability is tax-free, according to the president of the Canadian Life and Health Insurance Industry Association when he was talking in Parliament in 1997. Now, that's a parliamentary record. Personally, I don't think it's true. However, he went on the record. Now, moving on. CISIP has a cap on the cost of living of 2%. Now, I'm always criticizing this. I'm criticizing it because he's fucking stupid. Okay, I'm not criticizing for the sake of criticizing. Look, in 1973, Canada ended the 2% cap on the Canadian Forces, the RCMP, and the Public Service Superannuation Act, and the Old Age Security. In 1974, they ended the cap of the 2% in cost of living on the Canada Pension Plan. Took a bit longer because the Canada Pension Plan is harder to change. In 1979, they established the 3% rate for the Public Service Superannuation Act, Public Service Sun Life policy, and the RCMP's policy. They have a 3% cap. So, let's look at it this way. You have a disabled public servant, a disabled RCMP member. They have a 3% cap, and a soldier, disabled veteran, has 2%. You can't tell me that's not discrimination, okay? You can't tell me that's fair. So, as an interim solution, they should have to at least give you 3%. But again, that's just something to start the conversation. Once you start the conversation with the government, you bring it up to your member of parliament, you bring it up to the Veterans Ombudsman, you bring it up to the Canadian Forces Ombudsman, then you say, how come you got a 2% cap on the cost of living on the Service Income Support Insurance Plan since 1969? How come you weren't paying attention to the government's public interest, the public policy in 1973 when it ended the cap on all those other pensions? Okay? They won't have an answer for you because they're doing it to save money. Okay? They're doing it purely for avarice, greed. All they want to do is save money at our expense. Now, ordinarily, I'm going to throw a caveat in there. If you had a private insurance plan where you walked in off the street and you bought a contract of insurance, and that long-term disability insurance had a cap of 2%, you could have walked away. So what I'm saying doesn't apply if you won't go in and buy your own insurance. That's between you and the insurer. But when you're talking about a public insurance plan, public meaning, the government has it. They made it mandatory in 1982. They stopped people from having a choice in 1982. They made people buy it, but then they put a cap on it, and we didn't have any negotiation. We didn't sit down with them and negotiate terms and agree to 2% on the cap limit. Everybody seems to understand that it's unfair because in 2016 the government said it was unfair. Now that's the kind of thing that you don't have to go to court and prove it because the government admitted it openly. So they said that the earnings loss benefit would no longer have a cap on the cost of living. Now that was 4 years ago. How come the government didn't wake up and smell the coffee and change the limit on the CISA program? I have a theory. The theory is it would cost too much money because they'd have to fix it going backwards. You can't just pay people less than the cost of living and let them go into poverty as inflation eats away what their money can buy and then fix it on a going forward basis. You would have to look at the past, see how long the person was on the program, see how much inflation was. If it's less than 2%, there's no problem. But if it's higher than 2%, you have a problem because the person got less money than they should have. You see? So that's called damages. If you get less than what you should have, then someone has harmed you financially. So you are entitled to damages to make you whole. Now, moving on, because, again, I don't want to be at this. I don't want to be here today. My wife's gone to work these days. She's at CRA and she's working from home. But once a week she goes to CRA. So she's off to work. My son's there probably cringing if he can hear me through the wall. Because his room is right across from me, where I'm down in the computer room. Now, this is the fallout. Like the family fallout. Okay? Like, you see me out here talking. I'm always posting on Facebook. I used to do offline videos. I used to keep them to 2 to 3 minutes because I wanted to get an important message out in as short a time period as possible. But when I'm doing these Facebook things, I'm talking about everything under the sun. The next thing you know, I'm looking at a watch I got there, and I've been here for an hour now. I don't want to be doing this. Listen, the government could have been doing this all correctly. They could have no cap of 2% on CISA. They could have no clawbacks of the Canadian Forces and the Canada Pension Plan. They could have automatic entitlements when you get medical release. But instead of that, you could be getting CISA plus earnings loss benefit. But instead of that, they're making problems for us because they're creating damages. Look, they're going to have to pay a big bill eventually, because I wouldn't be here trying to get the word out if I was wrong. You can examine all of the things that I'm talking about. You can check into my facts. Do your fact checking, okay? I never get on the air and start talking about things without making sure I'm right first. It is stupid in my mind if someone would do that. I'm not like Donald Trump, saying things one day and then contradicting himself the next day. I am consistent. If you pay for something, if you have earnings, if you have savings, they cannot be used to save money for the person who harmed you. How stupid are they to try to say that they have the right to take into account things like the Canada Pension Plan? Because they're forgetting about the fact that the Canada Pension Plan was not set up to save them money. The Canada Pension Plan was set up to help people into retirement. It's not set up to help them. You see? That's the principle. What is the purpose of these laws? Anyway, I want to get this done because of the OCPD thing. CSIP has a survivor income benefit, but I don't think it actually ever pays it. Okay? So if you're on the CSIP program and then you die, your widow is supposed to get half, so 37.5% of your salary as the survivor income benefit. Now, I have a very strong suspicion that they set up this program, they never ever paid it out, and therefore the people, there are guaranteed to be people who were on CSIP who then died. It has to be a statistical fact. And those people ought to be getting half of the insurance that their spouse used to get. Right? Now, when they brought in the new Veterans Charter, they set up the exact same thing under the earnings loss benefit. But unlike CSIP, the earnings loss benefit side actually pays. And we were in an actual war, so people were actually killed overseas, and then their spouse gets whatever the government set up as the equivalent of the survivor income benefit. You see? Now, I've been pushing this one because of a widow, Joan LaRock. And I met with Minister O'Regan's staff with Joan about 3-4 years ago. And I came up with this brainstorm. I said, listen, Jacques died suddenly, so he didn't get CSIP. But how about we look at it and say, it's not fair for her to get half of the insurance. If he had been on the insurance one day and then died, I said she would have been entitled to the survivor income benefit. So, it's not the perfect solution, because she'd rather be under the new Veterans Charter system instead of the old Pension Act system. Because under the old Pension Act system, she is entitled to this much money. And I didn't know if, look, OCPD is a curse. I said, Joan might not like me saying it, but people should be in a free and open democracy entitled to make their own mistakes. She might be better off under the old Pension Act system because of its security. But if she wants to go under the new Veterans Charter, she ought to have the choice. And it's not up to me, it's not up to you, to tell her no. But the government wrote a law, you see. Section 95, if I recall, of the new Veterans Charter said people that are on the Pension Act can't switch over to the new Veterans Charter, or some shit like that. So, a lot of the stuff that I'm talking about, the government, would like us to have input and choices. Sometimes they take away choices, right? You can elect to buy your Canadian Forces buyback if you have time that you didn't pay into, but, you could buy it back. So you can choose not to, or you can't. My wife recently decided to buy back 6 years of service. So while she was a term employee, there were periods that she was working a lot, but she didn't pay into the pension. Now, I consider myself a pension expert. I told her I don't know if it's worth it to buy it because the government could change its mind. You might plan to get a pension, but they might decide to make these two things interact, and your buying this time back could mean that your purchase amounts to nothing. Now, I recently came to that conclusion because of two things that happened to me. I was on leave without pay when I was with Canada Revenue Agency, and I bought back 3 years of my time with the public service pension because, I thought it would be good. Now, I never thought about the fact that Sun Life would take the increased public service pension into account, and I paid my money to the public service pension for nothing. Now, I also did the same thing with the Canadian Forces Pension, the Reserve Force Pension Plan. So I bought back 1999, 2007, 8 years. It cost me $4,260. Now, because I paid that much money, I then got an increased Canadian Forces Reserve Force Pension Plan. But then when I finally got approved for the CISIP long-term disability insurance, they took my higher pension, and I got no benefit out of it. Now, I'm not a member of the Royal Canadian Legion, but I thought to myself, maybe I'll ask them for help. And I sent off an email to a service officer who passed up the line there recently, because I can't be the only one in this boat. I can't be the only one who bought back time back in 2007 to 2010 or so when they brought in the Reserve Force Pension Plan. But you don't think about the future, okay? And I can think of a case. In the Gill Supreme Court of Canada case in 1973, they said pensions are not absolute. A person could pay into the pension their entire life and then get out, and a month or so after they get out and get their pension, they could die. Or the person could die before they get a pension. You see? Now, I would add to that you could become disabled. You buy the pension back because you didn't anticipate becoming disabled. You thought you'd be better off when you retired. You then become disabled and you didn't plan ahead. You didn't think it couldn't happen to me, you thought. And then you become disabled, and then when you get your insurance, your increased pension is used against you. Now, you might say it's legal, but I say it's unjust. All things that are legal are not fair or just. So I'm trying to push this. I forgot to send a letter to the Public Service Pension, but I did do up the letter I gave to the Royal Canadian Legion for the Canadian Forces Pension. So I plan to push this, and I'm going to put myself in their shoes. I think they're going to say, this is a personal choice you made, and too bad about you didn't think about the consequences. Then I'm going to think of the Spinks Federal Court of Appeal case in 1996, and the fact that pensions are very complex, and they said that you need expert opinions, expert advice when you're taking these decisions. And then I'm going to say to them, listen, this case from 1996, that was well before I bought back my time. Did you give me any expert opinions, expert advice for when I was doing this about the eventuality if I became disabled, for example? And the answer will be no, because they didn't. Now, when I was at the public service, they might say you could go to your union. But when you're in the military, you can't say that you're going to be able to go to your union because you don't have a union. Okay? So the point is, if I wanted to, I could try to do a project on this, and I could try to find out how many people were in this exact same boat. But this is the problem. I keep thinking about things that I find intellectually challenging. It'd be fun for me to do. But it wouldn't be much fun doing it, because I'd be pissed off by the time I found that if I found out that X number of people had been ripped off by buying back their time and having their increased pension used against them, it'd trigger me like you wouldn't believe eventually. Even though at the point I'm talking to you right now, I think it would be a fun thing to do. In my mind, figuring things out is fun. See? Like, I have a call into the Commodore in charge of Canadian Forces Morale and Welfare Services. I intend to ask tough questions to him about, can you tell me, Commodore, about the program change for the Service Income Support Insurance Plan when it was transferred to the Department of National Defense from Treasury Board Secretariat? Now, I think the public has a right to know about that. See? I could ask him, okay, Commodore, how much money does the Department of National Defense remit to the provinces for the retail sales tax on the Service Income Support Insurance Plan long-term disability premiums? Now, the reason I would ask that if he called, is because you can't get taxed twice. If you get taxed on the premium, you can't get taxed on the insurance. So I will be getting to the answer about taxes by bringing up the systemic problem of everybody wanting to get their piece of the pie. The provinces put a retail sales tax. The feds put an income tax on stuff. Everybody wants to tax us into the ground. Now, it's an indirect way to do it. And so far, it's been about a week and a half. He hasn't called me back. I may have to do a second one, ask him for an official interview. But I don't think that they like having to answer tough questions. And I've been so public about all this stuff, I can guarantee you it will be an adversarial interview. Like the time I called the Vice President Larry Moore of CISIP. First time I called him, he was right snarky, being a fucking prick. Like, who is this fellow asking me all these questions? 5 or 6 months later, I called him again. This time he was right formal and precise and didn't give me a extra word. I was talking to him and asked him a question, and he'd say yes, no, stuff like that. So, believe it or not, I think the work I'm doing actually has some impact somewhere, right? I think these people are a bit worried because somebody is looking at it, looking at all these stuff, digging into the details. Like the Chief of Defense Staff took over the CISA program on the 1st of March 1990. Now, sometime between 2019, when the Defense took it over again, it went back to Treasury Report. See? So, most people wouldn't have noticed something like that, and they might say, who cares? Well, I care. You know why I care? Because it's against the law for Treasury Board to have it. Section 41.3 of the National Defense Act says that the Financial Administration Act does not apply to non-public property. Now, if you're a member of the CISA case, and if you're not, you can hear it from me anyway. The Service Income Support Insurance Plan was set up under Section 39.1 of the National Defense Act, which is about non-public property. So because it's about non-public property, it's about the soldiers' money being held in trust by the government, then Treasury Board cannot control that money because it's not their money. It's not taxpayers' money. It's the soldiers' money. So it goes back to the law, you see? So Section 41.3 says the Financial Administration Act does not apply to non-public property. It doesn't say Treasury Board can't run the show, but Treasury Board is a creation of the Financial Administration Act, so you had to put your thinking cap on. So if Treasury Board Secretariat is a creation of the Financial Administration Act, and Section 41.3 of the National Defense Act says that non-public property cannot be subject to the Financial Administration Act, then basically it's saying that Treasury Board can fuck off. No. I would go further. Okay? The Financial Administration Act, Section 7.1, brackets 2, says that once a contribution is made to an insurance or a pension, Treasury Board has no longer any legal interest in that money. So basically, Section 41.3 of the National Defense Act is exactly the same as Financial Administration Act, Section 7.12. Now, Section 7.11 is the authority for the government to put money into these programs. So Section 7.11 states that Treasury Board may contribute to pensions and insurance when it wants to. But Section 7.12 says that once the contribution is made, it's none of our business anymore. Think of it in terms of pay. You serve in the military or you work for your civilian employer. What you do with the money when you get paid is your own business, not their business. You see? So that's the principle in Section 7.12 of the Financial Administration Act and Section 41.3 of the National Defense Act. Why is it the government's business when it's our money? You see? That's one of my core ideas. Anyway, getting back to this, see if I got anything more left, and I think I got my throat wore out here. Getting awful dry. I'm drinking some orange pop here, but you see, it's taken a toll on me as well. My family, a lot of my friends on Facebook, I swear, don't listen to what I say because I posted so much. Now, I'm trying not to post as much anymore, but I'd say that I'm blocked or ignored by a lot of people. Now, I mean, I can't let it get to me. I'm not exactly very outgoing anyway, gotta be honest. I'm much of a hermit. Runs in my family. I call it Jarvis blood as a joke. Uncle Mike Jarvis, Uncle Johnny Jarvis, they hardly stirred out of their house. My Uncle Val Edwards doesn't go out of the house hardly. People have to go buy him things and stuff. So I blame it on the Jarvis blood. I hardly go out of the house, which is why I was surprised I joined the military, because that's a communal activity. I hate crowds. However, getting back to my point, okay, because I almost am through my outline, even though I put a lot of ad-lib there. And I jokingly say to people, my family, I said, I'm going to be famous or infamous about all this stuff I'm working on, right? People will hate me or love me based on all this stuff. But all I really care about is that they fix it. I don't really care whether people hate me or love me. I mean, listen, they shouldn't be doing it. In my world, you do what's right, you don't do what's wrong, and you leave people alone. If you leave people alone and you stick to the golden rule, do unto others as people do unto you, you shouldn't run into any trouble. But the government's getting into trouble because it's trying to do what the insurance and the employers across Canada are doing. So if they try to apply the principles that are used in the private sphere, then we're in trouble. because the government is not supposed to put its personal interest ahead of our interest. Now, the last 2 points I got. SISIP cannot be deducted from tort damages. That's a factual inference from the Salts, British Columbia Court of Appeal 2006 case, but it claims that it can deduct tort damages. Now, think about this. In the common law, the Bradburn rule says that you can't take a non-indemnity and contributory insurance into account to reduce someone's damages. Now, the government, being a government, decided to put it into contracts and decided to put it into statutory law and say that they can take into account your savings for retirement. See? So they're trying to take into account stuff that you would get anyway. The Canadian Forces Superannuation Act pension, if you have over 10 years, you're vested. You're going to get your pension. So, in theory, okay, I came up with this like a poison pill type approach. If you said to the Forces pension, the Public Service pension, the RCMP pension, listen, I'm getting money from Veterans Affairs, you can keep your pension because they're going to take it into account. Now, that's a short-term, short-sighted approach because you are entitled to your Canadian Forces pension in addition to any other money. So, you will be shooting yourself in the foot in the long run. So, what I've been telling people, like if they say, listen, Manulife is telling me I got to apply for the Canada Pension Plan Disability, I say, listen, 35 to 40% chance that you're going to get denied. But if you get approved, in the long run, it's good because you'll be allowed to get both. And you won't have to go get it after because you already were approved. But in the short term, it's going to be a pain in the arse because if you're getting SISIP, they'll take it into account. If you're getting the income replacement benefit, they'll take it into account. If you're getting the Canadian Forces pension, they'll take it into account. So in the short term, it's nothing but a nightmare. But in the long run, when I fix all this stuff and you're entitled to get all of what you paid for over time, you'll be getting your Canada Pension Plan. You'll be getting your Canadian Forces Pension Plan. You'll be getting your SISIP long-term disability. You'll be getting your income replacement benefit. And a lot of that will be tax-free. Because if you get something that's from Veterans Affairs, that has to be tax-free because of damages. So Income Tax Bulletin 365R2 tells about how Canada doesn't tax damages. So when they talk about income replacement, give them the middle finger and tell them, excuse me, but I get damages. I get damages. I get a capital payment for my injury. I don't get a payment of income. I'm not serving anymore. I get paid a payment in relation to the injury I suffered. And if you're under the Pension Act, you could say, well, I get a payment in relation to the disability assessment under the Table of Disabilities. So that is in no way related to my service. Right? Now, if you get a payment under the disability award and they tried to change the rules about that, you could use the same argument. I anticipate, you mark my words, I hope I'm wrong, but because the government is going to allow a monthly payment instead of a lump sum or an annual payment, I think CRA is going to try to tax what they call the pain and suffering compensation. Now you mark my words, because one of the things that they look at when they decide whether they're going to tax something is if the payment is made on a periodic basis. So when the payment was a lump sum, in their mind it wasn't taxable. Now that it's paid monthly, I think they might try to get their hands on some of it in the form of taxes. You want to see if I'm right? Look at the tax expenditure report from the Finance Canada people, and they talk about the uncollected taxes on the disability award when it was, the lump sum. So what the tax expenditure reports are their lost tax revenue. They aren't what they actually spend. They're what they could have gotten had they decided to tax the disability award. They put the Pension Act there and said like $200 million a year they could get in extra taxes. Now, this is absurd. It's completely crazy, right? Like, I'm not saying it's crazy to tax the money you get. I'm saying they're taxing it under the wrong provision. If you're getting capital and you want to tax it, you use the capital gains rules, or you don't use them at all. You can't claim a tax under the Income Tax Act rules on receipt of capital. So the legal nature of the money is really important. Okay? So if you get a receipt of money and it's income, you had to pay taxes. If you get a receipt of money that's damages, which is capital, you don't pay taxes because it's not income. You see? You don't go to work for the person that ran into you in a car and get money in exchange for your service, and they tell you what to do, and you do according to the letter of the contract, and then you get paid. No, you're getting paid money because you got hit by a car, and the person has to pay you back to make you whole. Now, if you get money from the government of Canada because you went into combat, or you were training for combat, and then you get monthly payments, or a lump sum, or whatever, the money is capital. If you get a capital payment, you can't get taxed as income. You see? That's my point, the big point. You could bring in moral obligation and the national sacrifice and all that. Not crapping on it, like I'm saying that those are moral judgments. I'm talking about legal arguments. What is the money? Is the money meant to replace your body, which is capital, or is the money income that it's a profit, right? The Income Tax Act is designed to tax a profit. So if you're in a business, say you set up a guitar making company or something else, or you decide to be a proprietor. A proprietor is when you go into business but you don't set up a company. So you have these skills. So you go into business and you only pay taxes on the profit. So you have expenses, outlays. You have revenue, income. When you look at the expenses, the revenue minus expenses, you have profit. If you have a profit, you have to pay taxes on the profit. But when you're a salary man, or, I watch a lot of anime, and that's what the Japanese have. They call them salary man. Or if you have someone who's employed, employer-employee relationship, they don't have any expenses because they had to pay for their own lunch and stuff, their own gas to get to work. So every dollar you get from the employer is profit, so you pay taxes on all that money, you see? But if you were a self-employed person, and you were, say, contractor, say, building houses or something, you would have your gas, your electricity, if you had employees under you, that would all be your expenses. And you would reduce your taxes by the amount of money that you paid out, you see? So again, this is going way too long. Holy shit. I must be on this an hour and a half now. Listen, I'm getting more out by this. I don't know whether I should keep going sometimes. But you know what? I was thinking maybe a more interactive show might be fun. If someone can either send questions to me ahead of time, or while I'm rambling on, send a question on the thing there, and although my eyes are going kind of blurry, I can probably change the bifocal angle and see if I can see it better. And then maybe I can answer some questions. That might be better to me droning on. But then again, I'm not trying to win any Oscars or anything. I'm not an actor. I'm just trying to convey information. Okay, so I don't care if I'm boring, although I'd rather not be. Nobody wants to be boring, but I think all the topics that I'm doing are artificially interesting to us because it affects us, because we're stakeholders. I can't help but think that. And then I say it out loud because of that OCPD thing. I speak the truth as far as I know. I could bite my tongue and not say it, but I won't lie. But I probably don't have to say everything I think. But the thing is it does get me into trouble. A fellow from the Royal Canadian Legion told me recently that the reason people in the government hangs up on me is because I don't give them a chance to speak. Well, that's not a very good judgment about why people hang up on me. When I called the Treasury Board and I asked them about the details of the transfer of ownership from the CISA program to the National Defense Department from the Treasury Board Secretariat, I wasn't being nasty with them people. I was asking them a question and the guy hung up on me. Now, I suspect it was because he didn't want to give me answers. See? People asking tough questions. Like, I don't have a mandate. It's not like I have a badge or a number and I'm working for the ombudsman or something, right? In the past, I'm going to sign off on this. There's one more point there, but I don't give a shit. I've been on too long. In the past, I said to the Office of the Veterans Ombudsman, listen here, I've been trying to help you guys and get all this stuff fixed. You pay me $1 a year so that it satisfies the conditions of the contract, offer, acceptance, and consideration. That will give me your authority, because I'm working for the Ombudsman. And then I can get the answers for all these problems I've been bringing up. Now, They obviously never took me up on that offer. They might have thought I was being stupid or being silly or I was crazy or something, but I'm serious. I would like to have a badge, the authority of some of these people who can demand answers from them. Because the Minister of Veterans Affairs, in their act, they have the authority to go to people, ask questions, and they have the power of an inquiries commissioner, according to the law. Right? Well, I see your point there, Jeff, but I've already got a book written. I was looking through it this morning, 522 pages. I have to pare it down before I get a publisher. And it's not really an autobiography. There's one chapter about me, but the book is mostly about the things I've been talking about. So if I can find a publisher, I'm trying to expose these bastards by my book because the media is not doing it. See? The way I look at this is the media should be doing what I'm doing. The media should be reporting on, say, the fact that people didn't get CISA between 1969 and 1999. So there's a cohort, there's a group of veterans that paid their insurance for 30 years, and then they might have become medical release. And it's not as big as you think, because the military never got rid of people until the 90s. So for the bulk of the time, you didn't have people get medical release that didn't get their insurance. Now, there were exceptions, like Joe Gunny Gillen. Joe Gunny Gillen got kicked out in 1985, and she never got her insurance. When she went to the battalion order room, she asked about the CISO application. They said, look at that pen there. If you can pick that pen up, you won't get it. Now, that is an awful way to look at it, because if you become disabled and you paid your contributions, your premiums to get a disability insurance, then you should get your fucking insurance, right? Now, I can't really blame the BOR too much because that's their experience. They were trying to help her out by telling her what everybody knows. But they shouldn't have had to say that to her because it should have been the other way around. If you get medically released from the military where you had a career, you have to get your insurance against disability. On that note, I'm going to call it quits, but if people want me to keep doing these, I'll try to keep doing them, but I'm getting more out by it. If people are tired of me getting here and droning on and on and on about whatever topic crosses my mind, give me some feedback. Say, Matt, save your energy, my son. You're boring anyway. But like I said, I believe because it's of interest to people, it's not boring to a specific audience that I have an intention to reach. That's the way I would put it. Okay? I could try to do a more professional show, and I have intentions of doing that one of these days. I did up yesterday a PowerPoint demonstration where I showed about the privacy consent problem with the Service Income Support Insurance Plan and the Veterans Affairs Rehabilitation Program. Because I've been told that I am at fault because I didn't send a 928E form in to Veterans Affairs. Now, I was livid when I got that letter from the minister in September 2019 because I went through my records then and I found a CISA FS 6E form that I signed on the 11th of April 2011. And then I put the fact that there's a program arrangement in place between these two departments. And then I thought to myself, and I told the OVO about it the other day, I said, if you have a program arrangement between these two departments about these two programs, and I fill out a consent form for one of the two partners, then it's stupid, absurd for me to have to fill out one at the other program. Because if you say that I had to fill out both, then why do you have a program arrangement? If you have a program arrangement because you claim that these two programs are so similar that you're going to harmonize them, then that's one thing. But if you then go ahead and do things that are wasting the public's money, because if you collect the consent form from the veteran under the D&D program, that's going to cost the taxpayers money because you have to collect, someone has to send the application. They then have to process it when it comes back, right? Now, then Veterans Affairs does the same thing. Then that's back to what I said at the beginning. I said that, these two departments are trying to defend each other's turf. They're trying to say that we're going to work together, but they're also saying we're going to keep ourselves apart. And they can't justify it. You can't say, if they get called into account by, say, the Auditor General, they say you have two different programs here. You say they're similar. You have a program arrangement. Then why do you collect two consent forms? Now, I would phrase it in a different way. I would say that the second consent is a violation of the Privacy Act, Section 4. So it's a breach of federal statutory law, a quasi-constitutional law. The Privacy Act is quasi-constitutional. So they ought to make sure that they don't get called into account on the legal front by breaking the law, because the person at VAC who demands these consent forms, they're breaching the Privacy Act, Section 4. Now, why should we pay taxpayers dollars to an employee of Veterans Affairs to breach a quasi-constitutional law? I wish I didn't know all this stuff. Anyway, on that note, talking too long. Thanks for watching. See you later.